I have a dream. Ladies and gentlemen, this dream is to hear about Professor Stern speak about the challenges arbitration is currently facing. This dream is to hear Professor Hanotiau explain what it truly means to be pro-arbitration. This dream is to listen to Professor Kaufmann-Kohler address concerns about neutrality when it comes to state-appointed judges in the multilateral investment court. This dream is to see Professor Zuleta discuss self-governance, relative non-regulation, and immunity. This dream is to find out whether I will win my bet, namely that Professor Bermann will not be able to resist joining the conversation, which is exactly what we are all hoping for. Please, please, don't judge me for my dreams. I plead guilty. But I also had a nightmare. How does one go about introducing legends, myth? After all, I could say that Gabrielle Kaufmann-Kohler has been, I would say, nominated or is regarded as the most influential arbitrator in the world, and I quote. I could say that Brigitte Stern is quite simply the queen of investment arbitration. I could say that Eduardo Zuleta has captivated the arbitration world with his decisions. I could say that Bernard Hanotiau is undoubtedly one of the most prolific arbitrators in our community, having worked on more than 800 cases. I could say that George Bermann is one of the... Oh, it's full? 700. I could say that George Bermann is one of the greatest scholars in arbitration and beyond. I could say all of this, but I will not. No, what I will say instead, and I know many of you here already know this, is that I now understand why each of you is a star, a real one. I remember Professor Stern paraphrasing Simone de Beauvoir, one is not born an arbitrator, one becomes an arbitrator. That may well be true, but what is also true perhaps is that one does not become a star, one is born a star. Because having had the privilege of preparing this fireside chat with you and of speaking at greater length with some of you, the first thing that struck me more than anything else was your personality. Yes, your stature, your kindness, and your sense of humor truly left a mark on me. Whether it was Professor Kaufmann-Kohler immediately wondering who on earth would want to listen to us talk about arbitration for over an hour and a half, or Professor Hanotiau's boundless energy, or Professor Zuleta's calm when we discussed the topics, or that nearly 2-hour drink we shared in Paris, Professor Stern, during which I did everything I could, even enlisting Patrice, the waiter at La Closerie des Lilas, to convince you to come, or your emails filed with emojis, your fairy tale meeting with your husband in Cherbourg, and the artwork you so kindly showed me. I was also told about an evening where you were dancing on the tables of a bar in Bogota. I don't know if a video exists, but if it does, it is worth gold. I am 22, and I doubt I could do the same. In short, preparing this conference alongside you has been an absolute joy, truly. And then there is Professor Bermann. Professor, what can I say? 50 years at Columbia, 10,000 students, your central role in the restatement of the US law of international commercial and investment law, and so much more. As Robert De Niro would say, not too bad. To be perfectly honest, I think at some point my parents began to worry, who exactly is this Professor Bermann? It is true, I've probably written and talked to you more than to my own family this past year. Since we have an entire evening dedicated to you, I will save the praise for dinner. A dinner that is generously sponsored and hosted by Columbia Law School and its dean, Daniela Bebe, whom I would like to thank sincerely. I would also like to thank our sponsors, without whose continuous support over the years, the Columbia Arbitration Day would not have become such a leading reference in the world of arbitration. In particular, I would like to thank our platinum sponsor, Simpton Thatcher, our gold sponsors, Esali, Davis Polk and Wardstone, and our silver sponsors, White and Case, A&O Sherman, Gaillard, Benifat, and Michel Bayet Disputes, Schaeffer's Lindsay, Cleary Gottlieb, Covington, Continental, Debevoise, Gibson Dunn, Martinez, Quintero, Mendoza, Gonzalez, Laguardo, and De La Rosa, Paul Weiss, Paul Hastings, Skadden, Sullivan and Cromwell, Three Crowns, Aiken, and von Verbusse Isiera. I think I've studied them all. Let me conclude with a quote by Oscar Wilde, which Professor Stern recently used when telling me about her trip to Easter Island. Beauty is in the eye of the beholder. Professors, even heaven knows that everyone looking at you today is beautiful, but you should know that you are as well. Thank you.
Thank you, Charles. Eloquent, as usual. Well, it's for me a dream, speaking of dreams, to be on this stage with four of the individuals I most admire in the world of international arbitration. It's really a treat for me. I was surprised at the extent to which they were willing to discuss the questions that I presented. I am responsible for the questions, but the answers will be what's interesting. And so we're going to move across quite a number of issues in the little time we have. There are four of us, four other than myself. We have four questions that deserve far more time than they're going to get. But we're going to do the best we can. What we hope to do is have each speaker present their initial views on the question that I have presented, and then an equal amount of time for comments among the five of us. And then we'll certainly encourage you, given who we have on the stage, to pose questions or comments before we conclude. And don't feel obliged, this is important, don't feel obliged to ask questions or make comments on the subjects we discussed. You may want to know something about their careers, their views about arbitration, or whatever it is that you think they could share with you that you would benefit from. Now, I want to start with Brigitte, who's going to address a fairly well-established topic for sessions such as this, and that is, as you might expect to be a topic here, the current challenges facing international arbitration, be it commercial or investor state. Brigitte, at your preference. I think it will be investor state.
It works?
Oh.
Okay. Well, I cannot start to speak without saying how thrilled I am to have been invited to participate in this world event to celebrate the career of my friend and colleague, George Bermann. As he just said, I will speak on some current challenges to international arbitration, which is, of course, an impossible mission in 10 minutes. Let me start with a citation of George Bermann in an article entitled "What Does It Mean to be Pro-Arbitration?" published in Arbitration International in 2018, where he wrote, "Shortcomings notwithstanding, international arbitration has been overwhelmingly a success story." And I fully agree. While my purpose here will be to concentrate on such shortcomings and challenges. Of course, international arbitration is not a monolithic concept. On the one end of the spectrum, there is commercial arbitration between two private entities subject to private international law. At the other end of the spectrum, there is international arbitration between two states subject to international law, and in the middle, there is investment arbitration between one or more private entities and the state, which has an hybrid nature, being partly commercial, having private aspects and public international law aspects. Not to speak, of course, about multiple, more or less autonomous systems of arbitration. I'm thinking about sport arbitration, and there's a court of arbitration for sport, which I have practiced when I spent a month in Sochi for the Winter Olympic Games in 2014. Not skiing, just judging. I'm also thinking about the ICANN, dispute resolution procedure, which I have also practiced with a case where there was a fight between a Cayman company that has deposited the domain name .republican and the United States Republican Party, which considered that it had a priority on that appellation. I don't tell you what the result was. The general picture being set, my short remarks will of course concentrate on ISDS, International Investor-State Dispute Settlement, which is the domain I know best. But I will here and there also try to make some mentions of commercial arbitration. A first challenge, in my view, is conflicts between systems of law. Of course, the most evident one, not necessarily for Americans, but certainly for Europeans, is a conflict between European law and public international law. I think that a panel entitled EU and Public Policy in Arbitration, How to Resolve the Crisis, will touch upon this topic tomorrow, and I cannot in a few minutes, of course, analyze such a complex legal issue. I guess many of you know Achmea, which, by the way, maybe you don't know, it is a very nice pink flower. You just look on internet, Achmea plant, so you can look. And Achmea and Komstroy. So by way of summary, let me remind you that the European Court of Justice has ruled that EU law precludes any arbitration clause in intra-EU BIT and in the European Charter Treaty. Interestingly, the court has distinguished commercial arbitration in saying inter alia that it's based on consent, while investment arbitration would be based on a treaty. Personally, I think this dichotomy is completely false, as investment arbitration, you agree, is also based on consent. Well, this being said, in investment arbitration, the decisions of the European Court created an open conflict between European law and international law with which arbitrators were faced. In fact, as we certainly know, almost all tribunals, to a few exceptions, have not followed the judgment of the European Court. It is indeed of utmost importance to understand that the international legal system is a general system of law, but which is not centralized, and which is made of many subsystems of international law that have to cohabit. This was, for example, explained in the Escosol versus Italy with an interesting graphic in paragraph 181 for those of you who are interested in art. Of course, the situation is now even more complex with the adoption by the European states of the agreement on the termination of intra-EU BITs, whose precise effect has still to be determined. So I must also make a caveat here, and all what I said here, of course, is I speak under the control of Bermann, George Bermann, as he is a Jean Monnet Professor of European Union law, and he knows probably much more than I do. A second challenge is, in my view, insufficient diversity, and this has, of course, multiple aspects. I will first mention the imbalance between men and women. It has been said, women hold up half the sky, because with the other hand, they hold up half the world. Well, this is far from being the situation in arbitration, at least in investment arbitration, but also in commercial arbitration. It appears that in commercial arbitration, the percentage of women, according to the ICC, is only 21%. And in fact, in the almost 200 tribunals, not 800, in which I've been sitting, there is only one in which we were 3 women. My husband, who is a mathematician, said that if things were equal, I should have 15 such arbitration instead of 1. Gabrielle might have a different experience. Second aspect of diversity is a geographical imbalance. We are all experiencing it. There should be more lawyers from our countries than the OECD countries. This is a responsibility both of state and investors to nominate arbitrators coming from the south and not always from the northern club. And why not arbitrators coming from NGOs? Third aspect, and this concerns only investment arbitration, is that there are not enough arbitrators coming from the public international world. Too many arbitrators do not understand that the state is not a company or that a state enterprise is not a state. Of course, I do not speak about my colleagues sitting here, which are quite knowledgeable in public international law, especially when they are sitting with me, but that's a joke. Why is it important to have public international lawyers as arbitrator in investment arbitration? Well, it's precisely to take into account not only the protection of investors, but also the situation of sovereign states, which entails special rights and special obligations. Special rights first. It has to be remembered, and it was mentioned in the preceding panel, that no state has an inherent right to arbitration or to a jurisdictional recourse. In national law, when you have a right, you have a tribunal. In international law, it's different. You need a special consent to go to international arbitration. In general, to an international tribunal, for example, also the ICJ, you need to consent. And this is why it's of crucial importance to verify that a state has consented before a tribunal asserts jurisdiction, so that the sovereign state is not judged against his will. And in fact, I am very sensitive to this issue, and all my dissents, but one, were on issues of jurisdiction, in cases where I found that the state had not consented. But the state has also special obligations and missions. States have to fulfill missions of public interest, protection of the environment, health, and so on. And this was, for example, clearly explained in the decision on jurisdiction in El Paso versus Argentina, where the tribunal of which I was a member stated the following, and I quote, "A balanced interpretation is needed, taking into account both state sovereignty and the state's responsibility to create an adapted and evolutionary framework for the development of economic activity and the necessity to protect foreign investment and its continuing flow." Here I want to make a personal note. When preparing this fireside chat, it occurred to me that it's not the first time that I've been invited to speak at Columbia. I was here in 2007, invited to the second Columbia International Investment Conference. And my topic was the future of international law, a balance between the protection of investors and the state's capacity to regulate. And again, I was invited 5 years later, in 2012, to the 7th Columbia International Investment Conference, and my topic was predictability and flexibility in the investor-state relationship, striking the right balance. It seems, therefore, that the idea of a balance is a red thread in my thinking, and for that you need both arbitrators having a private law background and arbitrators having a public law background. There are, of course, many other challenges. The use of artificial intelligence, of which we have listened to an interesting panel, the coordination of international arbitration with national legal orders. And I'm sure each of you is thinking about other problems raised by international arbitration, whether procedural or substantial. But I would like to conclude on a more optimistic note. It cannot be denied that we hear today, coming from many parts of the world, that there is a crisis in international investment law. I think it is worth putting this so-called crisis in perspective. As a matter of fact, if we look at the chaotic world of today, where what could be called a tsunami of violence is dominated with a complete disregard of international law, and especially of humanitarian law as it has been shaped after World War II, I think that the international arbitration field looks as a domain where law prevails. It is, of course, true for commercial arbitration with the New York Convention, but also globally true for investment arbitration under the ICSID Convention or other rules. So I can conclude where I started and say that indeed international arbitration is an overwhelming success story.
Thank you, Brigitte. Thank you. I want to ask my colleagues if they'd like to comment on what Brigitte had to say or come up with a challenge. Eduardo, I think you're ready.
I have one comment, and that is that we have sometimes forgotten the impact that the European court decisions have in the rest of the world. We have focused just on Europe and what happened with Achmea. But if you look at the denouncement of treaties and the denouncement of the ICSID Convention made by Ecuador, by Bolivia, and the threats by Colombia nowadays to denounce the ICSID Convention, they invoke Achmea all over the place. And one has to ask, what has Achmea to do with Latin America? We don't have an energy charter treaty. We don't have that sort of. And the answer, at least in my mind, is because it's a reminder of the Calvo doctrine. We're going back to the Calvo doctrine, and when in Latin America, governments perceive that Europe is coming back to the Calvo doctrine, the normal reaction is, why don't we do the same thing? We have been criticized for ages because of the Calvo doctrine. Why don't we go back to what Europe is doing now?
Does this work? Do people hear me out in the back as well? Good. It's very nice to be here, and I'm very happy to be able to pay tribute to to the longevity and the brilliance of George's career. So congratulations for this 50th anniversary. I'd just like to react now on what I would agree was the return to Calvo doctrine, and that is indeed preoccupying. But I would like to come back on diversity. Diversity is certainly a serious challenge in investment arbitration, but also in commercial arbitration. Let me focus for now on investment arbitration and focus more on regional diversity than on gender diversity, because I see gender diversity progressing. It progresses slowly, maybe not as fast as we would wish it to do, but it does progress. So the same is not true of regional diversity, and I like stats and I like empirical data. I was very much struck by the ICSID's caseload of new cases last year, and there you see that most respondents are from emerging economies, and I had hoped, or I had thought that we might see an equilibrium developing with more cases against developed economies, but that does not seem to be the way the evolution goes. And I would like to put this in context with another stats that I have run for purposes of my classes that took regional diversity by period. And it was better at the beginning of investment arbitration. Now, why is this so? I don't have a definite answer, but I would have expected the regional diversity among arbitrators to grow, and it has not. It might have something to do with the professionalization of the arbitrator job, where more people from the West have sufficient cases to do only arbitrator work, whereas this is not the case in other parts of the world, but it's certainly something that does require serious attention.
Yes. In my opinion, one of the challenges also is that arbitration does no longer fulfill the purposes for which it was created. You know, when I was a professor of arbitration law at Louvain University, I said to my students, arbitration is an inexpensive, fast, and confidential method of dispute settlement. Well, if you take just confidentiality, it's no longer confidential. Every decision, even confidential, is published. I remember I had a case concerning a satellite, and we had to follow a training by a specialized agency in the United States. We had to destroy all the drafts that we were preparing. Certain nationalities could not have access to the file, and so on. We rendered the award the day after it was published in GAR. Arbitration has become very, very expensive. It's one of the big criticisms. You have very often bills on each side more than 30 million euro. It is very lengthy now. You know, you have problems from the beginning, problems for the appointment of the arbitrators, and especially appointment of the chairman. I had recently a case where I was appointed in an investment arbitration. The parties took 2 years to appoint the chairman. And then, of course, during the procedure, you have more and more you know, requests of any kind, every kind, sometimes the letter of the day, to use the expression of one of my colleagues. And then challenges. Challenges become a big problem. Institutions are complaining. Recently, we delivered an award, and we were challenged after the award was rendered by the losing party. And with this kind of argument, Mr. Hanotiau, well, it was rejected, but each one of us had its own grounds. For me, for example, Mr. Hanotiau, in 2014, the expert who appeared in this case was an expert in one of your cases, and you did not disclose it. Another one, the party who appointed you is member of the same organization than you. I said, bizarre. And it was the advisory board of ICA that has 58 members, and we never meet.
Thank you. This is actually a bit of a segue because what I'm going to ask Eduardo to talk about is something that I have observed, and I expect you have, and that is that the practice of international arbitration is self-regulated, largely self-regulated. I don't know very many service providers that provide services as consequential as we do, that are self-governing to the extent we are. If you're self-governing, you're probably better equipped to meet the challenges that we've just been talking about. One of them I think we've met, transparency. Not fully, but we've certainly made, through self-regulation, we've made gains on transparency. So, Eduardo, I ask you to reflect a little bit on whether you, and to what extent you think we are self-regulating, to what extent you think arbitrator immunity is in play, and to what extent, and what you think the consequences are of the fact that we really regulate ourselves.
Okay, thank you, George. First and foremost, I want to congratulate you for your years of services at Columbia Law School. It's been a privilege and a pleasure to know you for so many years. You've been a mentor, you've been a light for so many students and for so many practitioners in arbitration. So I want to thank you in public for
Thank you, Eduardo.
all you've done for us in arbitration. I know that is a subject that you love, and you wrote an article in 2020 on that particular self-regulating point. And you made an analogy that I liked a lot between the existential autonomy of arbitration and what you call in your article a separatist political movement. Because arbitration at the end, like a separatist movement, which is the analogy that you make, is a group of norms or regulations within a territory, but with freedom and independence from many of the norms and practices of the legal order, from which it is separating, enable arbitration to function with freedom and with absolute independence in most of the times from legal norms. Arbitration today is self-governed in two ways. I would say, number one, by the creation throughout the years of a number of legal fictions, if I may call them that way. Legal fictions that today we see in the UNCITRAL model law and that we see in the modern laws of most jurisdictions. And when I refer to legal fictions, I refer, for example, to the autonomy of the arbitration clause. That is a legal fiction, because if you apply civil law, or you apply the law to the fullest extent, then the arbitration clause is just part of the contract. Then you have the legal fiction of competence, by means of which the arbitrators have the exclusive jurisdiction to decide on their own jurisdiction. Then you have the ability of the parties to determine their own procedural rules, which under the procedural traditions of most jurisdictions in the world a number of years ago would have been unacceptable. You would have to submit to the courts. But in addition to those legal fictions, then that are incorporated today in legal norms, you have a body of soft law that has been created mostly by arbitrators themselves. Not even, there's a belief that this soft law is being created by institutions or associations. But if you see who has led the dramatic changes, it has been arbitrators. Johnny Wieder led a dramatic change in the LCIA rules. Alexi Moore led a dramatic change in the ICC rules. Arbitrators, a group of arbitrators led the amendments on the IBA rules and IBA guidelines on conflict of interest, the creation of the IBA guidelines on party representation and the like. So it is a self-regulated environment. But I would have to put a note on this issue of self-regulation and taking something that Gabrielle and Brigitte mentioned on diversity and inclusiveness and the like. And this, how much of the soft law rules are being driven by US practice of arbitration as opposed to a truly international practice of arbitration. The expectations of the parties are not the expectations of counsel. The expectations of the parties are driven by their cultural formation, by their traditions, and the parties expect different outcomes in the arbitration. The expectations of a US party are not the same as the expectations of a Spanish or a French party in the way the procedure should be conducted. So one question is whether we are going too far in adopting practices and soft law that is more tailored to US practice and US way of doing arbitration as opposed to something that is more universal. If you look at the statistics today, 30% of the cases are Latin American cases in ICC and in ICSID. African cases, same. So we have to look a bit into that. That's a side comment I wanted to make on that. Now, the fact that a regime or that a system is self-governed does not mean that it is isolated from criticism. On the contrary, the more isolated and the more self-governed, the more the criticism it will receive, particularly nowadays when there is a perception that arbitration is some sort of escaping the authorities and the legal norms. If you look at the position of a number of states vis-a-vis arbitration today, Brigitte was mentioning the decisions of the European Court. We've seen challenges against arbitrators all over the place for a number of reasons, as Bernard was mentioning. We are seeing attempts to annul awards based on the perceived or real sensation that the one or the arbitrator or the tribunal itself was biased, that the tribunal was not properly constituted, etc. And those are signs that affect the legitimacy of arbitration, and we need to deal with that, and I will come to that in a second. The second part of your question refers to immunity and whether there is really immunity for arbitrators today. The question is a very good question, and I saw Bernard and Gabrielle saying no, and I would agree. Is there immunity for arbitrators today? I don't think there is immunity for arbitrators. We have a very loose regime all over the world where you have the dilemma that we have always had between the duty of arbitrators to decide on the conflicts that are put to them and to dispense justice on the one hand, and the liability of the arbitrators, the duty of the arbitrators to behave on the other hand. The answer a number of years ago seemed straightforward. One would say, and in looking back at the article that I was mentioning, well, yes, there is immunity for arbitrators, but I don't think that is true anymore. In the US, there's almost absolute immunity with certain exceptions. But if you look at other jurisdictions all over the world, there's nothing similar to an absolute immunity. And going back to the two continents I was referring to because of the number of cases that we have had there, in Africa, jurisdictions coming from a common law tradition, for example, Kenya comes to mind, have some rules for immunity of arbitrators, with certain exceptions that are the normal exceptions in the cases where the arbitrator clearly incurs in criminal offenses or duties that are beyond the most basic duties of good faith. But then you go to civil law jurisdictions, countries like Rwanda, Mozambique, and Angola, the ones that and you have no rules whatsoever on immunity. So they will go and refer to the local rules for arbitrators, the rules for judges, and the like. Latin America is basically the same. You have jurisdictions where you have immunity, and you have jurisdictions where the law or the judges have repeatedly stated that arbitrators are judges, and as such are subject to the same liability of judges. And then comes Russia, which is a nightmare today. Number one, in Russia, the arbitrators have immunity, but they are liable for criminal conduct. And you know that in Russia there are two things that we must consider. Number one, there's a decree that considers that arbitrators from that venues, in the cases of arbitrations involving Russian parties, seated in venues that are considered non-neutral by the decree because those venues are located in states that have imposed sanctions on Russia. In those particular cases, the Supreme Court of Russia, the courts of Russia, have exclusive jurisdiction over the case despite the arbitration clause. On the other side of the coin, if you, as an arbitrator, want to sit on a Russian case, you will find another problem. That is, the Supreme Court has said that arbitrators bearing the nationality of states that have imposed sanctions on Russia and are not neutral. So what are the institutions doing? Appointing arbitrators from Latin America, from Asia, but then those arbitrators face the following problem. I sit in a case, and then the Russian court has exclusive jurisdiction, and any decision that I make would be a procedural fraud, which is a criminal offense under Russian law. So that, again, is a challenge that we have to. So what is to be done on both ends? And with this, I will conclude. On the issue of self-regulation, we need to revisit a number of issues. I would say that one issue that is dramatic today in self-regulation and that has resulted in a bunch of criticism is the form of appointment of co-arbitrators and the standards of independence and impartiality of co-arbitrators. There is a document that you have probably seen, a paper written by Professor Lucas Berkoulakis advocating for a sort of a tolerated bias in investment arbitration. That is an interesting departing point and puts the key issue of are co-arbitrators, do our co-arbitrators have the same degree of impartiality and independence of the chair in the panel? That's an issue that we need to tackle and we need to address. That's one thing. On the issue of immunity, I think that the institutions would have to collectively work with arbitrators on finding something along the lines of a protection for arbitrators in terms of immunity. The problem that I see is that institutions are competing against each other, and then they also, each one, of course, issues its own regulations that it considers competitive. And then you find yourself in a situation where, for example, rules that say arbitrators are immune to the extent permitted by applicable law. That and saying nothing is the same thing. So I would encourage the institutions. And last but not least, and with this I would finish, I think I remember the words of late Professor Orrego Vicuña once, saying, the problem is that arbitrators don't have a voice. And I wonder whether that's still correct. Whether do we have a voice in international arbitration? And a voice meaning not an individual voice, but a collective voice.
Thank you, Eduardo. I'm sure we have some thoughts about self-regulation. Let me just say a word about immunity. I have to say that the United States is an outlier. We are a very big outlier. When we drafted the restatement of the U.S. law of international commercial and investment arbitration, the reporters proposed qualified immunity. We won't go into the definition here of qualified immunity, but it is obviously not absolute immunity. And that was voted down by the American Law Institute members. And the prevailing view in U.S. courts, I think it's wrong, by the way, is that arbitrators are to be analogized to judges. Judges have absolute immunity in the U.S., and arbitrators perform adjudicatory functions. Now, that is the reasoning of the law in the US. I think we haven't caught up with trends in the world in that way. It causes me some concern that there would be no accountability at all. To me, that's a concern. I think it is for you, Eduardo. We don't want accountability out of control, of course, but a degree, certainly, of accountability. And in the US legal culture, that is not welcome.
Yes. Are arbitrators regulated or not? Yes and no. Yes, to some extent. I'm a member of the Brussels and Paris bar, and the bar doesn't make a difference between my activity as counsel or my activity as arbitrator. So I'm regulated. I'm also regulated by, for example, the guidelines on conflicts, which are extremely strict, more strict than the same conflict rules that apply to judges or to counsel.
That's self-regulation.
Yes, that's self-regulation. There is I don't think there is immunity of arbitrators. I don't think there is immunity. Even if there is a provision on immunity in the ICC rules or in the ICSID rules, you are responsible if you commit gross negligence or fraud, everywhere. My problem is the evolution nowadays. In the past, arbitrators were a very limited group of very prominent law professors. And nowadays, you have a multiplicity of arbitrators. Maybe a good thing to some extent, but let's suppose that in your respective countries, the legislator decides from now on, everybody who has a law degree can be a judge in national courts. Oh, you would say, but this is not possible. But this is what is happening in arbitration. Everybody can be an arbitrator, and there is no regulation in that respect, no accreditation. Judges, they have to follow, well, either have some experience as a lawyer, either they have to follow a number of courses before being accredited, but there is no accreditation for arbitrators. And this is, in my opinion, the main problem.
Well, that's certainly the case, and that's what drove my interest in the subject, which is, again, as I said, I don't know service providers that play as important a role as we do that are completely unlicensed and not regulated in any particular way. But that doesn't mean we aren't regulating ourselves, and we are very much. We can come back to soft law later. Let me just add that I don't think the undue American influence is reflected so much in soft law as it is in arbitral practice. In arbitral practice, Anglo-Saxon, and I mean US, US practices are prevailing. And there was no necessity for that. And I wonder, and I'd love to know from my colleagues here, as to why you think it is that things like cross-examination or discovery or other features have become standard features of international arbitration, even though while you were back in your own country's courts, you would not practice them. What explains that? I don't know if we get a chance to answer that question, but I think that's where the Americanization of international arbitration lies mainly.
Can I disagree for once with you, George? And it's not on the last point that you touched, but it's on regulation. If I now look at regulation as regulation of the arbitrator's office, I find that the arbitrators are regulated actually more and more, and the era of deregulation has passed. For a very long time, state had left a wide space to private actor, which filled the space with all kinds of soft laws and practices. Now I see a change. The change is most evident in investment arbitration, but I don't think commercial arbitration is insulated in the sense that there will be a contamination, and there may already be one. You see, for instance, the institutional rules have been reinforced in terms of requirements towards the arbitrators, in terms of disclosure, in terms of availability, declarations of independence, and the like. And then we have had last year in investment arbitration the code of conduct for arbitrators, and that is a very specific, demanding document, for instance, in terms of disclosure. I don't view this as soft law in the sense that it is adopted by states. So it is the states who want to put their house in order, and they have said so very clearly during the debates. And in terms of impartiality, my friend Stavros Bekoulakis says theory that impartiality does not apply in such a stringent fashion to the party-appointed arbitrators is categorically rebutted by the Code of Conduct for Arbitrators, and that's the Code of Conduct of UNCITRAL and ICSID. So it will become the norm, really. And so I see, to the contrary, an increase in regulation clearly coming, not a surprise. It's in l'air du temps, in the sense that we have return of the state since the aftermath of the financial crisis in 2008, and that does not spare international arbitration.
You know, Gabrielle, perhaps I wasn't as clear as I should have been. When I said self-regulation or unregulated, I mean unregulated by the publicly unregulated. I put international arbitral institutions in the arbitration community. In other words, well, I see them as part of the community. They may not be arbitrators and they may not be counsel, but I tend to view the enactment of these codes of conduct and the other things you've described as ways in which the arbitration community is regulating itself. And the government is not. And I think we are enjoying self-regulation through our institutions.
Can I grant you the point on the institutional rules. I do not grant it in terms of the Code of Conduct for Arbitrators, because while this was drafted by the institutions, it was elaborated, it was discussed and approved by the states. So for me, this is a governmental or a state enactment, more or less. And you see more and more treaties that do refer to the Code of Conduct. So it is then integrated into the treaty framework.
I think you're right that we're seeing some of that. But I think Bernard is correct. We are unlicensed. There are no barriers to entry into this field. I mean, it is remarkable. We don't need a continuing education. We get it from our institutions, but we're not required, as lawyers are, at least in this country, to have continuing legal education. And in that sense, I think we're not publicly regulated. I think you're correct about codes of conduct being endorsed by states. Other views?
Maybe no, I just wanted to answer one of your earlier questions, saying why did the practice of the United States, like cross-examination, document production, is now all over the world. First, I think it's a very bad thing, and I will explain. But second, I think it's just the result of a balance of power. I mean, the United States have imposed this because probably there were more arbitration, or I don't know why. So I think there would be one of the reasons that arbitration now lasts so long, and Bernard has mentioned it, is all these, for example, cross-examination. I think as a civil, coming from a civil law country, I think I look at the documents and I don't need someone to tell me what the document says, and probably often he is wrong. And for document production, I mean, this has become quite horrible. We have 500 pages of document production, usually in the main case. I mean, the most important case, maybe there are 50 documents that are needed. And I think that it would have been much better to apply, at least what I know in the French, which is le truc accusatoire, la position accusatoire, which means it should be the tribunal asking for documents, not the parties.
Why have the Prague Rules, which sought to distance international arbitration from our methods, they haven't gained much traction, have they? The Prague Rules?
I didn't understand.
Okay. The Prague Rules, which were elaborated with a view to escaping the Americanization of arbitration.
Yeah, but it hasn't worked out.
But an effort was certainly made. Right, Gabrielle? An effort was made.
Yeah, an effort was made. Maybe it was not well made, and it was too extreme on the other side. I see the remedy to the issue of what I call complexification of the proceedings, and these procedural tools are part of it. It's just to reduce the use of these procedural tools. You can tell the parties you will file no more than 20 document production requests, and if you need more, if you really think you need more than 20, then ask the tribunal and explain why you need more than 20. When they ask you, when the parties, it's not the parties, it's counsel, tell you we need 3 weeks of hearings, you say, no, 10 days is sufficient. And it's very rare that you get a pushback. If you, of course, you have to say things that are reasonable, but within reasonable bounds, there's a lot that proactive arbitrators can do to channel the proceedings without completely disregarding what we have been doing for so many years, and which also has its benefits.
Well, arbitration certainly has the autonomy to distance itself to some degree from the practices that prevail in this country. Eduardo, did you want to add something?
No, just to go on your question on why the U.S. influence in international arbitration nowadays. If we look at in the past, arbitration was the realm of France, Switzerland, Germany, but then you started seeing the expropriations in decolonized countries, and then U.S. law firms came in because they had expertise in litigation involving the massive handling of documents, the massive handling of this type of huge litigation that probably other firms worldwide didn't have. And they came in and started influencing the arbitration the way we see today. And we are today, I couldn't agree more with Brigitte. I wonder every once in a while, do we need really a cross-examination of 3 hours asking a witness to read me what the document says? Do we need a document production with 1,000 documents being asked? And the expectations of the parties, a Spanish party and a French party, do they have the expectation of this sort of procedure? or they have the expectation of a more civil law-tailored proceeding?
Now, I want to change gears a little bit because time's running out. I asked Gabrielle to address a question on which she has written, and I've benefited from her writing with Michele Potesta, and it has to do with the proposed reform of ISDS in the form of a multilateral investment court. Now, one of the major objections, and I see Charlie Brower here, so I know you'll have something to say. One of the major objections to the establishment of a multilateral investment court, which, by the way, I think we will get in one form or another, I don't know how many countries will buy into it, is the fear that the judges being appointed by states will lack the neutrality that we expect of arbitrators in the current system. Because it is assumed that ultimately those who will decide investment disputes in the multilateral investment court will be individuals named by states. Now, Gabrielle, you've paid a lot of attention to this question, and I've understood you, perhaps mistakenly, as wanting to at least come up with some ways of mitigating that fear. And I think that the audience would benefit greatly because we're going to have a court. We don't know its architecture. And we don't know how many states will buy into it, but I'm sure we're getting one. Gabrielle, can you help us on, can you quell the anxieties at all that the arbitration bar is feeling?
Quell at all, I don't know, but it is true that the composition of the court, the proposed multilateral investment court, for which there are draft statutes being discussed now in Working Group III of UNCITRAL, is one of the main challenges in respect of this court. And the goal is to have a competent, diverse, neutral court. And so here I just focus on the neutrality point.
Yeah.
And neutrality to me is just one facet of independence, impartiality, so it is not an additional concept. It's just used here to say neutral in the sense that not pro-state in spite of having been appointed exclusively by the states. When you speak of independence, impartiality, it was independence, you distinguish two types of independence. One is personal, individual, and that is what is at the forefront when we speak about arbitrators, not having to have connections with one party. The other one is institutional, structural, and that is what comes into play when you shift from an ad hoc system like the one we have now, ad hoc because you have ad hoc tribunals, to a permanent body of dispute settlement. And so how do you avoid the risk of lack of structural independence? And that risk does exist. Now, at the same time, there exists a number of possible remedies to either eliminate the risk or at least reduce it. And they're related to three elements of the court's governance. The first one is the selection and appointment process. The second one is security of tenure. And the third one is the method of allocating cases to chambers. And let me take one after the other. The selection appointment process first. It must be framed in such a way that the individuals selected are selected for their personal qualities and not on the basis of political or other considerations. And so to avoid or reduce this politicization risk or the vote trading type of issues, what you would need is a multi-phase appointment process that would be composed of a nomination phase, a screening phase, and then an appointment phase. And we, of course, have many examples of national courts, of international courts. We have good, we have bad examples. We have a wealth of literature. So there's a lot of sources from which we can draw lessons of what to do or what not to do. So the process should be multi-phased. It should be open in the sense that it should build in consultations with all the stakeholders, and of course one first of all thinks of business organizations which could represent the views of the investors. It could also include open calls for candidacies in the sense that I could just apply to be a judge, or Bernard could propose that I'm a judge without being proposed by a state. Another factor of the openness could be that the appointment is not entrusted to the contracting states that have ratified the statute of the court, but to some supranational body of representatives of national parliaments. That is so for the European Court of Human Rights, and it works relatively well in the sense that it detaches this from the influence of the governments. It could also be an independent commission that reflects the various constituencies of the court, and here often one cites the Caribbean court that has the system that is said to work well. Doubtful whether the states would accept to relinquish that much power. The process should also be, in addition to multi-phased, open, it should be transparent, because public scrutiny of the process should enhance the legitimacy. You could advertise the openings, you could publish the CVs of the candidates, you could even imagine public hearings for the selection. The second possible remedy to avoid the risk of lack of neutrality is security of tenure. A judge should be protected from interference during the term by those who have appointed him or her. So you need a guarantee against removability, of course, but for serious breaches of duty. Long, non-renewable terms, because that avoids pressures on renewal. And financial security seems obvious, but may be useful to state, through proper remuneration and pension. The body also as a whole should have adequate resources to avoid that budgets can be used to put pressure on the court. The third and last element is that cases should be assigned to chambers in a manner, and it assumes that the court would have several chambers, in a manner that gives consideration to the fact that disputing parties cannot predict the chamber, and that would avoid maneuvering to get before one specific judge rather than another. So this is the theory. Now, how does it look in practice at this, where we stand now in the Working Group III discussions? There's a draft statute, as I said, for a court of October 2025, so it's quite recent. the judges will ultimately be confirmed by, appointed by the contracting states, but there are a number of safeguards that have been built in. A three-step process, as I outlined it before. The nominations are by states. However, the states shall carry out, it says shall, consultations with stakeholders, and there's a long list of stakeholders. And the states can, that's a can, that's not an obligation, make open calls for applications. Then there's a screening committee composed of either former members of the court, members of other national courts or of highest national courts, and other people lawyers of high standing. They screen the candidates and they interview them and make recommendations to the contracting states. Then it goes to the nomination stage. And what I should also say is that the screening committee, if it is unsatisfied with the nominations it gets, it can call for open applications. The term is also provided, should be one long, non-renewable term. Presumably it will be 9 years. Of course, for the judges and for the screening committee, there must be a proper geographical distribution and diversity, both gender diversity and, of course, regional diversity. So there are a number of safeguards put in place to avoid the risk of the lack of neutrality and the pro-state bias. Hopefully, it is important that the community works on making sure that the best quality judges are being selected. However, at the end of the day, I don't think the court will stand or fall on the quality of the judges. It will depend on the political will of the states, and the states is unlikely that they will make their decisions on the basis of the considerations we discussed now. They seem not to recognize anymore the creature they set up decades ago. So let me stop here.
Let me just say this. No one has thought more. Don't be modest. Nobody has thought more about this than Gabrielle. And I believe Working Group 3 has been influenced by what you have written. Brigitte?
Yes, well, Gabrielle, thank you very much for your interesting presentation, but you have not alleviated my concerns about the 15-headed hydra, to take the denomination used by Charles Brouwer. I have a lot of problems. First, we know that any nomination implying states necessite, of course you said there are lots of screening, but the screening do not help that states say, well, you nominate me this one and then I nominate you someone in another body. So I'm not sure it will be as evident to find a good panel of judges. But I have more concerns. Today, for example, in ICSID, last year, there were individuals of 36 nationalities entering into the arbitration field. And of course, here we will have only 15, so diversity might be reduced. Huh?
The number of judges is not fixed.
Ah.
No.
Yeah, but probably not 36. Well, I don't.
Well, the idea is that it should grow depending on how many states adhere to the court.
Okay.
So,
I don't know.
we don't know. It
Okay.
could be less, it could be more.
Okay, okay. Now, another concern, and this is more profound, is that if you have a first decision which is wrong, a court has a tendency to continue the jurisprudence, and we have this different approach of precedents. But I think that there is a good chance that the first decision, if it's wrong, it will be repeated and repeated. Of course, it's coherent, but it could be coherently wrong or wrongly coherent in a way. And last but not least, is that still arbitration? Because I think arbitration is a settlement of disputes where both parties choose their arbitrator. So I think it's no longer...
No one has ever said that this would be arbitration. This is international litigation like before other international courts, and the regional human rights courts are a good example. There is this confusion that arises from the EU system that they have included in the CETA and the Vietnam FTA, the Singapore FTA, where they try to make use of the exit enforcement mechanism for something that is not really arbitration anymore. And that is a somehow hybrid solution that will probably not work.
And according to
they be judges.
According to the project, I'm not sure I know, will the immediate enforcement of exit arbitration remain?
Yes, I mean, the exit convention is not touched. The only thing you need to do with respect to the exit convention is a protocol that would be an inter se protocol in terms of Vienna Convention on the Law of Treaties for those states of exit who accept the court because that is, of course, different than what the exit convention provides. And more importantly, now I'm switching in my reasoning to the appellate mechanism. There's also a project on an appellate mechanism that would be superposed on existing investment arbitration.
Bernard.
Yes. One day ago, before coming, I said that we have already an international multilateral court, the CETA. It has not yet. It has not yet been. Well, it is existing. It has not yet worked. But I asked ChatGPT for my information. Who are the 15 arbitrators? They gave me the names, and you know, when you ask a question at ChatGPT, they ask you, "Do you want something else?" And the question was, "Can I give you the profile of these people?" I said, "Yes." And no, it was more precise. "Can I give you the profile of these people and whether they are pro-state or pro-investor?" I said, "Yes." And I got the answer. This one is clearly pro-state. This one is clearly pro-arbitration. This one is moderate. This one is clear. Okay, so they were all classified.
Can you not say this of the current arbitrators?
Sorry?
Can you not say the same of your current
No,
arbitrators?
and by the way, something that also strike me is that at least one of them, I don't know the others, but one of them is also a very active counsel. So there is also a risk of conflicts of, conflicts of interest. Okay, but so it seems that the composition of the court at CETA reproduces if these predispositions are right, exactly what we know today.
Mm-hmm.
Okay, so, and you know, I also read the draft statute which is being discussed. And at the preamble, it says, mindful that concerns have been raised regarding the high cost and long duration of such arbitral proceedings, lack of consistency. Okay, cost, but it's going to be much more expensive. But of course, lawyers are not going to charge less. There's not going to be a big difference because the arbitrators are, you know, permanent arbitrators, or there's not going to be a big difference. But there's going to be a registrar, a secretariat, so it's going to be much more expensive. And there is an appeal mechanism. Most people who will use the mechanism, especially states, just for matters of accountability. Length, but it's not going to change, it's going to be worse. Because with this appellate mechanism, an arbitration that lasted 4 years is going to last 8 years. Well, finally, yes, and consistency. You know, we have in our jurisdictions, commercial courts or labor courts, that have to decide the same issues. And you have different jurisprudences. Do you think that it's not going to be the same with these different panels, that all these judges will have the same opinion on various issues? I don't think so.
Okay, a last comment.
One last thing. Investors will lose the possibility of appointing their arbitrator. There are 150 states that have ratified the Washington Convention. I don't think that all of them will be represented one day in the tribunal. So it's a loss for investors.
Okay, Gabrielle, very short because
I'm very short. I will not enter into any of these points, but to say that this is not the issue. The issue is that a number of states want to do something different, terminate treaties, and if we want to make sure that what states put in place partly in place, because there will always be treaties with providing for arbitration, put in place something that is as good as possible, then we better engage. That's my only message.
I think we're going to have Q&A on this. I'm looking at you, Charlie. Before we do that, Bernard, I asked you to think about something that you may or may not have wanted to think about, but it is this preoccupation of mine about how do we determine whether a policy or a practice is pro-arbitration. That's something I've written about, as you know, and I'm really interested in your thoughts on this. We don't have much time, so there may not be conversation, but let's hear from you.
First, like all my colleagues, I'm so pleased, so proud to be here to celebrate your 50 years of teaching. And I'm also very happy to be here because more than 50 years ago, this is the school where I graduated. Well, what does it mean to be pro-arbitration? Well, it looks like a simple question, but it is not, for various reasons that I will examine. I note first that the question may be asked at various levels. Is a practice pro-arbitration? Is a policy pro-arbitration? Is a jurisprudence pro-arbitration? Is a legislation pro-arbitration? Is a legal system as a whole pro-arbitration? Moreover, as we will see, a policy or practice or legislation may be pro-arbitration in certain respects and no pro-arbitration in another respect. And moreover, a practice or legislation which does not seem to be totally pro-arbitration may be justified by the promotion of other values which support the legitimacy of arbitration. I will examine these issues successively. Let us start by an attempt to give a definition of the concept. And I must say that I've tried to find a definition, a very clear definition of what is pro-arbitration. I did not find one. So consequently, in order to determine whether practice or policy or legislation is pro-arbitration, the best way is probably to ask yourselves a series of questions, such as the following questions, which are not the only ones, and which moreover may overlap. To what extent does the relevant legal system enhance the scope of party autonomy? To what extent does it expand the categories of legal claims to be arbitrable? To what extent does it effectuate the likely intentions or expectations of the parties? To what extent does it, consistent with the parties' intent, enable the tribunal to exercise sound discretion and flexibility on matters of arbitral procedures? To what extent does it guarantee a fair and honest arbitration process in compliance with due process and the principle of equality? To what extent does it guarantee the independence and impartiality of the arbitrators? To what extent does it provide for the time and cost-efficient intervention of national courts, if and when needed, to guarantee the integrity of the arbitral process or the effectiveness of the award? But to what extent does it also minimize the monitoring or control of national courts in the arbitral process at all stages of the procedure? And finally, to what extent does it enable the resulting award to withstand challenge and an annulment or enforcement action? Well, these questions offer a wide range of ways by which the measure pro-arbitration character or any given policy or practice or legislation is pro-arbitration. But, and this brings me to the second aspect of the issue, assessing a measure pro-arbitration character is by no means as straightforward as it might initially mean. A measure that advances arbitration's purposes according to one of the criteria may fail to advance another arbitration's purpose in other respects. In other words, a policy or practice may serve arbitration's purposes according to one measure, but actually serve them according to others. Let's take the use of witness statements in lieu of direct testimony. Replacing witness testimony with written witness statement is largely viewed as pro-arbitration because it demonstrably saves time and money. But on the other hand, it creates the risk that counsel will write the witness statement and that the witness statement will be manipulated or perverted. Let's take also the scope, the determination of the scope of the arbitration clause and whether a non-signatory can be included in that scope. It is definitely pro-arbitration to permit an arbitral tribunal to decide this issue itself. But in some jurisdictions, unless the issue has been explicitly reserved to the arbitral tribunal, it is for the courts to decide this. A court entertaining the objection entails delays and complications that may be detrimental to the economy of the arbitral proceeding. But on the other hand, doing so vindicates the principle of consent on which arbitration is based. So both positions are arguably pro-arbitration depending on which goal of arbitration is given priority. So what emerged from this is the necessity of managing trade-offs that competing pro-arbitration considerations entail. And Professor Bermann has suggested in this respect that one way to ascertain whether a given policy is on the whole pro-arbitration is proceed in cost-benefit terms by weighing how far a given policy or practice may both serve and disserve arbitration's interests. Beyond that issue of trade-off, and this brings me to the third and final aspect of the issue, a policy or practice may be disproportionately favor a pro-arbitration consideration at the favor not only of other pro-arbitration considerations, but also at the expense of considerations that are largely extrinsic to arbitration, but nevertheless of considerable value or utility. Well, in that respect, we all know that the international arbitration community has consistently rejected policies and practices that would appear to be pro-arbitration when they would also appear to prejudice important values that are largely external to international arbitration itself. Let's take the IBDA guidelines on conflict of interest. Compliance with these guidelines undoubtedly delays and complicates arbitration practice, but it is widely regarded as justified in the interest of fundamental fairness and societal value. Another example is the restrictions on arbitrable matters in a number of jurisdictions. For example, labor disputes in many countries are not arbitrable. It is pro-arbitration to permit an arbitral tribunal to deal with all possible disputes. On the other hand, it is important to protect workers and make sure that by accepting to have access to have their disputes submitted to arbitration rather than by national courts, they do not lose some of the benefits that they were granted by the law. So here, a trade-off with there is a trade-off with the social value of protecting the community of workers. Another example is arbitral immunity. The rationale of arbitral immunity is that exposure to litigation and liability may affect the independence of the arbitrator. However, accountability considerations may point in the other direction. Arbitral immunity presents a clear trade-off between the pro-arbitration value of ensuring that arbitrators operate without reprisals, and on the other hand, the extrinsic value of accountability. So in conclusion, whether a practice, a policy, a legislation is pro-arbitration or not is a complex issue. A given policy or practice may be pro-arbitration in some respects, but anti-arbitration in others, and in this case, a trade-off of some sort is required. And the determination of whether a practice or policy is pro or anti-arbitration also requires to take into consideration values that are largely extrinsic to arbitration itself. Thank you very much.
Thank you, Bernard. In the interest of entertaining questions and comments, it could be a comment and not a question. But we've put a lot on the table here, I think, and so we would very much welcome comments or questions from the audience on anything we've discussed or anything on your mind.
I've sat under her chairmanship in 4 cases. In one case, James Crawford and she agreed that Canada had done the right thing in a NAFTA case. The other 3 cases, I dissented. Now, you make it sound like what we call taking the LSAT test to be able to go to law school. People take exams, get tested in some way, they go through a process. Now, the reality is politics will be involved. They're always involved. I've seen them at local level, state level, national level, and international level, including at the International Court of Justice system of getting judges elect, to some extent the International Criminal Court. I think the EU view is the worst attack on friendly dispute settlement between people or companies that have differences. Now, I'm not as confident as you are, George. I've heard some things that make me still doubtful. I don't know if they've gotten to the money question yet, but I figured it would probably have the biggest chance of breaking down on who's going to contribute how much to this bureaucracy. You can't have so-called judges without a huge bureaucracy, and it costs a lot of money. And if 27 countries, the EU, are going to fight over that, and maybe some others, I think it could take a while. Now, one of the alleged strengths of this is consistency. If you get an outfit like that, it'll come out with consistent decisions, especially if it has an appellate part, which is under consideration. I can guarantee you nowhere in the world are 27 countries, or however many join, which also have provinces within them, and that this is not going to get political. Countries are going to be putting up, there'll be fights there as to who gets this, whether they're taking tests or not. Our judges in this country, federal judges, do not take tests. They get politically chosen. And by that way, we get some pretty good judges and sometimes not so good judges. But if this ever goes through, it's not going to be a happy place. Nobody in their right mind is going to want to go there. And you have totally dissolved the way that foreign investors and their host countries, one way or another, get together because they've agreed to do it in a sometimes friendly way. Don't believe there's an easy way to. I remember, and that'll be the last, Brigitte Stern, with whom I've sat a lot of times, and Johnny Veeder and I were having dinner, or maybe it was lunch one year, and we were talking about this, and we looked around and they said, they'll never choose anybody like this. They're like us. We know too much. I'll give another speech tomorrow.
Okay, thank you, Charlie. You delivered. Yeah, please.
Thanks. James Costello from Paris. George, I agree with you that the community, all of us, owes a great debt of gratitude to Gabrielle and to her colleague, Michela Potesta, for the papers that they've done for UNCITRAL. However, Gabrielle, I was surprised to hear you say that this, in a kind of you seem to be reconciled to it, that this doesn't have to be thought of as an arbitral institution, the new court that is envisioned. Because my recollection was that at least in your and Michele's first paper, you had spent a lot of time trying to analogize the multilateral investment court to an arbitral tribunal, and you especially relied on the Iran-U.S. Claims Tribunal, where all of the judges were appointed by states. What you said today makes me a little worried. It made me agree with Professor Stern that we just had another session last week in Vienna, and the statute that's before us very clearly expects to rely on the New York Convention for the enforcement of, I don't know whether we can call them awards anymore, but the decisions of the Multilateral Investment Court in those countries that have not contracted into the multilateral court. And I would expect, at the beginning at least, that there would be a lot of those non-contracting countries. I tend to think that even long-term, there might be quite a few of those non-contracting countries. So knowing that I think most practitioners feel there's an increasing recalcitrance among governments in paying awards or decisions against them, even though the language of the MIC would require them to do that, just as the Washington Convention requires them to do it. So if it's not going to be an arbitral award and we can't rely on the New York Convention, shouldn't we be as concerned as Professor Stern is?
I don't know whether I should answer now. Jim, you're closer to the debates in Working Group 3 that I have been recently. To me, if I were a national court, I would have to look closely into a decision issued by judges on a permanent court being considered an arbitral award. But I'm just saying this like this. I have analyzed this in the first report quite in some detail. That's true, because essentially because of CETA. Yeah.
Something, Jim, on this. You're certainly right about enforcement, at least unless and until we get the Hague Convention, right, that would guarantee enforcement of judgments. Enforcement will depend on the New York Convention. Could you imagine this being a court, but the standards of the New York Convention being applied under the statute, let's say, borrowing the New York Convention?
I think there is an attempt to do that. I mean, one of the points we were just discussing last week is whether that is going to be successful, because other language in the statute says that you renounce any further review. And the question is, isn't Article 5 of the New York Convention some kind of remedy or review?
True. Well, I think we've reached the end of our session here. I think you will agree with me, won't you, that a lot of interesting items were put on the table, and there's a great deal more to be said about all of it. Perhaps that will be private conversations. I know you're going to join me in thanking our panelists for their candor, for their originality of thought, and for their diversity of views. So let's give tribute to our panel. Thank you.